is LA County and Ventura County. It's very clear that it applies to all counties impacted by that. And definitely Orange County is impacted by that. All it means is impact that is that people from LA and Ventura are coming here to try to rent properties, which I'm sure has happened. I was in San Diego a couple of days ago and they were saying it's happening there. It's happening in Riverside, San Bernardino County, Santa Barbara County. The Attorney General pretty much said Southern California is all covered by this law. So, and they're being pretty aggressive going after not just property owners, but realtors who represent property owners who are renting the properties for more than they should. The good news is most of the people they're sending warning letters to. I got a call on the hotline from a realtor, and she was actually crying because she got this letter, and I said, stop crying, you should be happy, you got a warning letter. They are not going to arrest you. You are being told that as long as you bring the rent down, you're okay. Stop crying. But anyway, but at least a couple of realtors, they haven't sent warning letters to, they've actually arrested. So basically, because this is a penal code section, right? This is not a messing around thing. And remember, the basic rule is, first of all, the good news is this is not going to be in effect that long. States of emergency typically last 30 days, which would end February 6th. This one looks like it's going to be extended to March 8th. But beyond that, it's not going to be impacting you. I mean, even if they extend it further than that in LA County, that won't, the Attorney General has already said, well, as far as the outlying areas, we're not going to continue with that law. But what they're saying right now is, don't increase the rent by more than 10% more than it was rented before. What if it's not rented now? Was it rented in the last year? Don't do it more than 10%. What if it wasn't rented in the last year? What if it was never rented? Then you got this formula. You go to this HUD, you just Google HUD, fair market value, fair market rental value, and it directs you to this thing. You punch in a zip code, and it'll tell you how much you can rent like a 4-bedroom house in that zip code. Of course, if you look in this area, it'll probably be a lot less than the market rate, which is causing a lot of consternation. You know, the market is twice as much as I should be able to rent it for. People are coming to me, and it's not like I'm asking for that, they're offering that money. So I should be able to rent it for more than this HUD number. And the answer is you just can't. But there is an exception. If the tenant will sign a lease of more than a year, 12 months and 1 day, 13 months, whatever, you can charge as much as you want. What you cannot do, at least until March 8th, is charge someone rent beyond the numbers I just said in Orange County. I mean, they're more aggressively going after LA County landlords, obviously. But they've also made it clear, though, that this covers all of Southern California, at least till probably, maybe February 6th, maybe March 8th. So just try to, and the realtor can't say, well, I'm just working for my client. I'm doing what my client wants. That's not a defense, right? It's also not a defense to say, well, we offered it at $10,000, they're offering $20,000. What am I supposed to do? And the answer is, don't take the $20,000. Because that would violate the prohibition, okay? Any questions on this before? Yeah?
Well, I've read a couple places where people have gotten a lease because they were willing to pay more and they were the first one who was willing to pay more.
Well, the fact that they're willing to pay more doesn't mean the law is not being violated. I mean, that's the big thing. If they sign a lease for more than a year, that's a way around it. But people don't want to rent it out for more than a year. Don't rent it out for more than a year, then don't charge too much, at least for the next couple of months. Just because the tenant is willing to pay it, offers to pay it, and we could argue the merits of this, but the point is, and we're trying to get the law changed, but that takes months. We're also trying to get the Attorney General just to make a declaration that we're not going to enforce this against blah, blah, blah in certain market areas where the market value of the rent is clearly so much higher than blah, blah, blah. But they haven't done that yet, so, yeah.
Do they take into account, as opposed as a movie theater?
They take into account nothing. The question is, how many bedrooms does it have? That's all it is. I know not every house is the same, obviously.
Oh, movie theater, like,
doesn't matter what you, I mean, by the way, what if, and the chart only goes up to 4 bedrooms. What if you got a 5-bedroom, you can add 15% for each bedroom. You can also add, if it was previously rented unfurnished and now it's rented furnished, you can add another 5%. But bottom line is, I mean, obviously you're creatively trying to find loopholes to avoid this, and there aren't any right now, other than the 2 year, the more than a year thing. Yeah. Raise your hand, yeah. Yes?
Does the whatever you want price after the 12 months for that restriction, does that only apply to homes that have never been rented before and that receive?
Or that haven't been rented in the last year? That's a great question. In other words, what if I'm in a property that has been rented? Can I still get away with this? If as long as I rent it for more than a year, I can charge whatever I want. And they're saying on that one, no. So that thing I said you can get away with charging whatever you want if they sign a lease for more than a year. At this point, they're saying that only applies to properties that have not been rented in the last year or never rented. So that's a very good question. Yeah. That's a very big area of confusion. What's confusing is just landlord-tenant law in general. I mean, none of you should ever increase the rent without calling a lawyer, because there's so many other things to think about. Because now we know this 10% thing, but that doesn't change the fact that there are already rental restrictions. The Tenant Protection Act says every rental property in Orange County and everywhere else that's 2 or more units, 15 years old or older, and the tenants have been there 12 months, you can only increase it by 5% plus inflation, which in Orange County this year is a total of 8.6. So on those properties, you can't increase it 10%. So when we're talking about this anti-rent gouging, we're really only talking about single-family homes. If it's not a single-family home, you can't even raise it 10%, unless the building is newer than 15 years and the tenant's been there less than 12 months. So that's the confusing thing. We already have this 10% thing in our mind. That hasn't gone away. Well, like in LA City, where you can't increase the rent by more than 4%. That's still in the case, just because, I mean, you can't all of a sudden increase it by 10%. So you have to look at what's the strictest. The local law, the state law, or this, single-family homes, where normally you can increase the rent as much as you want. Thankfully, remember we defeated Prop 33? If Prop 33 had passed, that would have meant the cities and counties and the state could have restricted rent increases on single-family homes. That's why we're so happy we beat Prop 33. So the only time now single-family homeowners cannot increase the rent as much as they want is when we're in this state of emergency that we're in right now. That's the thing. Yeah.
On the HUD zip code chart,
Yeah.
aren't you allowed to take 160%?
That's what I mean. I should have made that clear. Sorry about that. When I say the HUD chart is going to show you a number, 4-bedroom house in this zip code. You can multiply that by 1.6 and then add 10% to that. I'm sorry, I should have made that clear. But the people you guys are telling us that's still way low. That's still way below market. But unfortunately, right now, that's the issue. Be glad you're not in LA County. In LA County, I'm guaranteed this state of emergency is going to be extended and extended, and I wouldn't be surprised if it's a year.
10 years.
It could be the rest of your life. Who knows? But the point is, they've already made it clear that in the areas that are not under a state of emergency, this is ending no later than March 8th. So you guys only have to deal with this for a short time. They got to deal with this up in LA. It's going to be months and months and months. So silver lining, right? Yes.
I have a specific question.
Yeah.
Because they could
Yeah.
snake people around. So I currently have a situation where I've rented it out for the last number of years, and have
Single family home.
single-family home. She's what I call a small landlord. She's not a big
Yeah, yeah.
institutional landlord. When this is that, let's say we put a 1-year tenant in, subject to the 10% rent increase.
Right.
As before.
Right.
Year 2,
Yeah.
can we bring it up, which would be.
You can increase it as much as you want. There are no restrictions on how much you can increase rent on single-family homes, other than a state of emergency. I mean, you can make up for it by quadrupling the rent. There's no restriction on how much you can charge on single-family homes. Yeah.
For an LA County single-family home.
Right.
With an existing tenant
Right.
That landlord can raise that LA County single family existing tenant.
Normally, I'd say yes, but not right now, because the state, 10%. 10%. Now, maybe what you do is you just get the new tenant in there and do a month to month. So you're not restricted, so when this ever goes away, you can just boom, increase the rent. I mean, if you give them a lease of a year, then even if the state of emergency ends in 3 months, you can't obviously increase the rent till the end of the lease.
So is it, if it's 365 days or less, then it's 10%, but if that existing tenant you want to sign a 2-year lease, we can increase it any amount?
That's the same question I asked of her. Right now, they're saying no. And we're lobbying hard for this. Right now, they're saying this exception for leases of more than a year only applies to properties that have not been rented in the last year. Yeah, we think the law doesn't say that, but the Attorney General is the one. I mean, if any of you want to volunteer to be the test case, if you lose, you go to jail. But if you need a test case, you can test it. But we're trying to advise you to be conservative. And you guys in Orange County, I mean, we have to worry about this for a short period of time. It's not going to, LA, it's a much, they're going crazy in LA because it's, the state of emergency guarantee is going to last in LA. It's just not, and God forbid you have fires, you'll have to deal with the same thing. So, I know you've had fires in the past. Yeah.
With the, it hasn't been rented the last year.
Right.
You're 1 day charge whatever you want.
Exactly.
How do we handle, the part of that section says shall not be defense of prosecution, that the increased rental pressure is based on the length of the term.
But you gotta read that whole section. And the Attorney General has gone on record to say what I said. So I'm not just saying, we got the Attorney General to say that last week. So, yeah, the language of the code section is sort of ambiguous. It really is, which is, and I could read it the same way you're reading it, but at least the AG sort of clarified that issue. So, we can come back to this. Let's talk about other stuff that's going on. A little bit of good news. Occasionally I give you good news. Rarely give you good news. Occasionally I give you good news. A couple of laws that were going to be in effect are all of a sudden not going to be in effect. One of them that all of you were supposed to do said that every business, pretty much in America, that does business in the form of a corporation or LLC, and your revenue is less than $5 million, you had to report to the Department of Treasury, federal department, this form, this corporate transparency form. You had to report the name of your company and the DBA you had, the principal place of business, and anyone who owns at least 25% of this company or basically controls it also would have had to report their name, their driver's license number, their home address, and a couple other things. So this was a law, and the deadline for doing this was December 31st. I'm not going to ask how many of you actually did this. The good news is you don't have to anymore. A couple of weeks right before the end of the year, a judge said this is unconstitutional. Court of Appeal overruled that. Supreme Court dealt with it. The bottom line is right now we have an injunction in place that says this law is not enforceable. So any of you guys who were putting it off to the end of the year and never did it, you are good. All right, so don't worry about that. And by the way, this even would apply to agents. A lot of agents create corporations just to have the commission paid into their corporation. This would have applied to you. So that's not happening. Another thing that all of a sudden is not happening, I don't know if it affects any of you. You know the concept of cold calling? There's a do not call list, right? If someone's on the do not call list, you can't cold call them. But did you know even if someone is not on a do not call list, you can't do automated calls, robot calls, unless they give permission. Well, traditionally people give blanket permissions for this. Like lead generators get people to sign, saying, oh yeah, I'll take a call from anyone. And then you get this names from the lead generators and you can just call. Well, there was a law that was supposed to take effect 3 days ago that was going to say, no, people cannot give blanket consents anymore. And if you were going to, even if they weren't on the do not call list, if you were going to send them an automated call or text, you had to get each individual person's permission for that. that didn't happen. It got reversed. It's not going to happen. So if any of you do robocalls, robo-texts, and you're doing this based on a lead generator giving you a list of people and saying these people gave a blanket consent, keep doing it. Nothing has changed. I'm only telling you this because you may have heard about this. I heard there's a big change about making automated calls, and there was going to be a big change. It just didn't happen. I mean, it got overruled the last one. So that's good. That is the extent of my business. Okay, let's go back to that. All right. Latest update is, let's talk about the latest developments on the topic that all we talked about was last year. All we talked about last year, which is the buyer broker stuff. A couple of clarifications. Remember, August 17th was the day of the settlement. So for the rest of our lives, we're going to refer to anything that happened before August 17th, 2024 as the good old days, right? 3 years from now, I'll talk about the good old days. You'll know exactly what I'm talking about. But that settlement was appealed. There's several appeals. And people ask me, is there any possibility this thing could be overturned? And we're going to go back to the good old days. Number one, unlikely. But number two, even if that happened, we now have a law in place. Doesn't matter about the settlement anymore. California law requires you to have a buyer-broker contract. Now, remember, the settlement applied to residential only. It said if you work with a residential buyer, you can't show them a property without having a buyer-broker contract. It didn't cover commercial or land. Then the law that was passed says this also applies to commercial and land. However, the law, as written, says you only have to get a buyer-broker contract before you write the contract. So theoretically, you could show a property, commercial or land, without a contract as long as you don't write the offer. That's what it said. But now the DRE has already announced they're coming out with a new regulation that's going to basically say, well, the law says you have to get a buyer-broker contract as soon as practicable, but no later than writing the offer. They're going to go out with a regulation that says as soon as practicable basically means before you show it. Which means the law and the settlement are going to say the same thing, which means whether you're representing residential, commercial, or land, don't show without a buyer-broker contract, okay? And by the way, that law applies to all licensees, not just realtors. Okay, so that's one change. Second, the law made it very clear that, okay, how long can these contracts be? 3 months, right? It also made it clear that you can only renew it for 3 months at a time. And you can't have an automatic renewal. You can't say in the contract, buyer and I have this contract for 3 months. If neither one of us cancels, it automatically extends for 40 years. You know, for another 40 years beyond. I mean, extensions can only be every 3 months, and it can't be automatic, so the buyer's gonna have to sign something each 3 months to extend it. Now, 3 months. I understand 3 months, you understand 3 months. Apparently people are having a problem with 3 months. People say, well, if a buyer-broker contract starts on February 1st, it's only going to 3 months means like 88 days because of February. But if you sign a buyer-broker contract on March 1st, it's going to be 91 days. So not every buyer-broker contract is going to be the same length. And my response is, so? No. People can't handle that, so they're going to change the law. It's no longer going to be 3 months, it's going to be 90 days. If this hasn't happened yet, it'll probably happen in April or May. All right. You know, there's also something called a continuation clause, right? I mean, you've always had a safety clause in your listings, right? Where somebody lists with you for 3 months, but then you say basically, yeah, if someone who's been introduced to the property in the first 3 months buys it after that, I'm still my listing, I'm still covered, I'm still get paid as long as they buy it within a certain period of time, right? So we have the basic listing plus the safety period. There's the same thing with the buyer broker company. It's called the continuation period. So in other words, your contract can say, we have a 90-day contract, but if I show this property to somebody in those 90 days, and they don't write the offer until after the 90 days, I am still your agent, as long as they write it during the continuation period that we've agreed to. That's also no more than 3 months, right? But if you really think about it, that sort of connects you to someone for like up to 6 months. right? So theoretically, you're sort of protected for 6 months, at least for properties you show them. Another interesting thing is, you've noticed that the buyer-broker contract has a cancellation clause. Listings don't. When somebody signs a listing with you for 4 months, that's a 4-month listing. They're stuck with you for 4 months, you're stuck with them for 4 months. There's no cancellation. The buyer-broker contract says even if you sign a 3-month, 2-month, 90-day buyer-broker contract, either side can cancel before that. Can I just cancel or do I have to give notice? Well, up until a month ago, the form said if it was a non-exclusive buyer-broker contract, either one can cancel. You or the client can cancel instantly. But if it was an exclusive buyer-broker contract, you could only cancel with a 30-day notice. Have you noticed that's been changed? On the BRBC now, when you're filling it out, when it talks about cancellation, it says if it's an exclusive buyer-broker, it can be canceled within notice of 30 or blank days. You could write in 10, 15, 0. You and your buyer could agree that even if it's an exclusive buyer-broker, either side can cancel instantly. It's up to you how you fill that out. Remember the difference between an exclusive and a non-exclusive? An exclusive buyer-broker contract means if they buy anything during the time period, you're their agent. Non-exclusive means if they buy something you showed them, then you're their agent. So it's a distinction there. Question?
What's the best case, worst case penalty that an agent can get in terms of not securing a buyer-broker contract, and who is the prosecuting agency that's going to prosecute that agent?
Very good question. So, in other words, what are my risks if I ignore all this and violate? Okay. And there are unfortunately 3 risks. Number 1, the MLS, as part of the settlement, is required to investigate and prosecute realtors who violate. That's part of the settlement. They are agreeing to enforce these laws. Each MLS is different on what the fine is for violation. I've seen it up to $15,000. Number 2, the individual consumer can theoretically sue you for damages. I'm not sure how they've been damaged, but they could. But now, as of January 1st, the DRE, it's California law. There can be disciplinary consequences. Which is why we say don't mess around with this law. Please comply, because I mean the consequences can be pretty bad. Now, getting back to what I just said on the continuation and the cancellation. So you sign a contract with someone. You're the buyer's agent. They sign a contract, 3-month contract, 90 days, whatever, and you show them a couple buyers the property. I'm sorry, you show this buyer, your client, a couple properties. Then 2 weeks into the deal, I don't like you, they cancel you. And then after that, they buy the property. How long are you protected? You're still protected for 6 months. I mean, so it was an original, they canceled the original 90-day contract, and maybe you had another 90-day continuation period. That means after they canceled, you can't show them any new properties. But anything you showed them before it was canceled, you're still protected for the full original 90 days plus any continuation period. So they're pretty much stuck with you for 6 months, even though they canceled you after 2 weeks. They're stuck with you only to the extent of properties you did show them. Anything you didn't show them, you're not covered. Okay? So, one other thing. Have you noticed on the buyer broker, people ask us this, they say, on the compensation paragraph, where you say how much they're going to pay you, you have 3 choices. You can put a percentage, which is I think what you normally do. You could put a flat fee, or you could put as described on attached compensation schedule. So people ask us, what the heck form is that? And the answer is we don't have a form. We've changed the language. It now says pursuant to attached broker-created compensation schedule. The point is, if you wanted to, you could do this. You could say to your buyer, okay, if you buy a house more than $1 million, I'm going to charge you this. If you buy a house of less than $1 million, I'm going to charge you that. Or you could say, if you buy a single-family home, it's this. If you buy a duplex, it's this. If you buy a Newport Beach, it's this. If you buy, you know what I mean? You could be flexible and creative if you want to. with the compensation. We don't have most of you, I think, are just gonna have a normal, just one number. But the point is, when it talks about attached compensation schedule, that's what it's talking about. So we don't have a form for that, is the bottom line. What else? Those are the really only changes, I think, in the buyer broker contract. People ask me all the time, how's this working out? And you know, based on the hotline questions we get, it's working out. People are still getting paid. And people aren't necessarily getting paid less either. Because the thing of it is, what was behind these lawsuits? Realtors get paid too much. And the reason realtors get paid too much is because buyers have no say-so in how much their agent gets paid. It was the listing agent determined it, and since if buyers could negotiate with their agents about their compensation would come down. That was the philosophy. All right, that's not necessarily happening. Some agents I know are actually getting more than they used to. They're saying, you know, in the old days, the listing agent determined how much I get paid. Now I can convince the buyer how great I am, how much better I am than anybody else, and they'll pay me 3.5%, 4%, 5%. And it's actually happening. I mean, on the other hand, the other side could happen too, right? I mean, a not so good agent could go out there and say, hire me, I'm not very good, but I'm cheap. And that's something you couldn't do in the good old days, right? Every agent got paid the same. When a property was listed, the listing agent says, I don't care if you're a good agent or a bad agent, you've got 20 years experience or this is your first deal, you get paid this. Now, theoretically, a buyer, when they're thinking about which agent to hire, could say, oh, you're really good, you're experienced, you got this, I'm gonna pay you more, or this, I'm gonna try you because you're new, but you're cheap, whatever. So, in reality though, we've been seeing a lot more of the first thing than the second thing. We're not seeing a lot of agents out there trying to get business by lowballing or whatever. We are seeing some agents out there getting more than they used to, advertising their expertise. Remember the number one thing I think you should sell yourself when you're either a listing agent or a buyer's agent? Hire me, I'm good, which means you will not get sued. That's the number one protection I think of when I hire an agent. Is this agent going to help me not get sued? Because bad agents lead to bad outcomes, which result in clients getting sued. Sell yourself on, your client's not going to get sued. Yes.
Do you have a sense, or is there any way you could even get those numbers of how many buyers are paying their broker's commission? How many buyers are actually?
Oh, I see what you're saying. Yeah, and the answer is, I can check, but I don't think so. So getting back to this, the other thing is, let me say two more things about this. Before I answer her question, I keep saying you can't show a property without a buyer-broker contract. There's a huge exception to that. You can show your own listings without a buyer-broker contract. So, and I don't mean just I mean any listing within your brokerage. You work for a big company, 100 agents, 200 agents, 1,000 agents. If any of those agents have a listing, you can show that to someone without a buyer-broker contract. You're showing it to them as the listing office. So if you have a listing, somebody calls you up randomly and says, hey, your property looks good, can I see it? Your first reaction is going to be, yeah, it's on lockbox or whatever, have your agent come by and show it. Oh, I don't have an agent. Your next reaction is going to be, I'll be your agent, hire me, sign a buyer-broker contract. And they say, I don't want to do that either. I just want to see the property that you have listed. You're perfectly allowed to meet them at the property and show it to them. If you do this, I strongly recommend you make them sign a form we have called the BNA, Buyer Non-Agency, where they acknowledge that the agent who's showing me this property is not my agent. They're not my friend. They're my enemy. They're on the other side. But the point is, you can do this. Same thing on an open house. You're sitting at an open house. If it's your listing or it's a listing within your company, somebody walks into the open house. And they don't just want to walk around on their own, they want you to show it, they want you to answer their questions. And answering their questions is the same thing as showing. You can't answer their questions unless they sign a buyer-broker contract, or if it's your listing. Now, just like I would recommend a form called the BNA if you're doing a showing, we recommend our open house sign-in sheet, OHNA, open house non-agency sign-in sheet, which is almost identical with the BNA. It's the same thing. Someone's coming to the open house, and they're acknowledging that you, the nice agent who's helping me, is not my agent. You're on the listing side. But you can answer their questions and show them around. What if someone walks into your open house? Not only will they not sign a buyer broker contract, they won't even sign this open house sign-in form. They're trying to get you in trouble. Don't help them. I mean, you can give them a flyer. You can give them the cookies and the water and the donuts and stuff, but don't answer their questions. You can't answer their questions unless they sign a buyer broker or it's your listing or your company's listing. What if I'm doing an open house for someone who's at a different company? You can't answer their questions. You think of yourself as an unlicensed assistant. I mean, anyone can host an open house. You could hire someone walking down the street, hey, you want to host an open house for me? As long as they don't answer questions, they can sit there, let people in, give them the flyers, and do all that. So, a little slight area of confusion there. Now let's go back to the compensation part. In the good old days, listing agent paid the buyer's agent. In the new world, that's not the way it works. How does it normally work? It normally works now is buyers ask the seller to credit them the amount of money they owe their agent, which is really not a new concept. I mean, you know, in real estate, to buy a house, a lot of people got to get paid. The title company, the escrow company, the HOA if it's a condo, the county assessor's going to get paid, the NHD company's going to get paid, the home warranty company's going to get paid, everyone's going to get paid. And on the purchase contract in Southern California, I've seen a million of them, they all say seller pays all these costs. So now there's just one more cost you're asking the seller to pay. And sellers are paying it. Because actually sellers aren't paying anything. Think about it. Does the seller really pay anybody? No. Where does the seller get the money to pay all these people? Do they go to the bank? And do they withdraw funds to pay? No, they don't pay anybody. Sellers don't even pay the listing agent. When you say seller pays, that implies to me the seller's writing a check. Where does the seller get the money to pay the listing agent? From the buyer's money. Everyone gets paid through the buyer's money. Everyone. Sellers don't pay anybody. And that's the way I would explain it to any seller who said, if I were a listing agent, seller said, why should I pay the buyer's agent? I'd say, number one, you've always paid the buyer's agent. Every time you've ever sold in a house in the past, you signed a listing at a higher amount so that the listing agent could pay the buyer's agent, meaning you paid them. But then I would really say to them, actually, you're not paying them at all. I'm not asking you to write a check to the buyer's agent. We're just going to divert some of the buyer's money to them, like we always have. I mean, we've always had the buyer's money pays everybody, and that hasn't changed. And the other way I think to approach it is, and by the way, so your question, we have statistics on it. That seems to be happening almost every deal. Now, obviously, what could theoretically happen would be buyer signs a contract with the buyer broker, I will pay you 3%. Buyer writes the offer, paragraph 3G3, they say seller to credit the buyer, concession 3%. Seller counters and says, I only want to pay the agent 2%. That means the buyer now owes the difference. Are we seeing that a lot? Not a lot, but we are seeing it. Now, I think that whole situation is a little misleading. If I were a seller, and I got an offer, and the buyer's asking me to pay their 3%, I mean, I'm not going to focus on that number at all. I'm going to say to my agent, what's the net I'm getting here? If I'm getting enough money, I'll pay their agent 5%. I'll pay their agent 10%. I'll buy their agent a Porsche if I'm going to get enough money. I mean, if I get 3 offers and one of them's asking me to pay the buyer's agent 1%, one's asking me to pay the buyer's agent 2%, one's offering me to pay the buyer's agent 3%, I could care less. I'm going to say to my agent, give me a net sheet for all 3 offers, factoring in everything they want. They want repair credit, everything they want plus the price. What am I going to go home with? And if it turns out that the one where they're asking me to pay them 3% is gonna result in the highest net for me, I'm gonna say that's the one I want. I don't care what the buyer's agent is getting. So I'm not gonna counter. If I get an offer and they're asking me to pay the buyer's agent 3%, I'm probably never gonna counter and say, no, I'm gonna pay them 2%. I'm basically gonna counter and say, you need to increase your price. I just need more money. I don't care how you allocate it. But I'm not gonna really counter you on how much you want me to pay your agent. That doesn't make sense. I'm looking at my bottom line. I think that's the way to approach it. Now, occasionally though, maybe you're running into a seller who has a philosophical problem with the buyer's agent getting paid a certain amount. I don't think buyer's agents should get 3%. And your response is, even if that offer results in more money for you, you'd rather take a lesser offer where the agent's getting less because philosophically you don't want buyers. I mean, seriously? Are many sellers going to think like that? Or we actually have heard of sellers who say, oh, the buyer's agent wants how much? Now, who's that buyer's agent? Oh, her? I've dealt with her in the past. I don't like her. I don't want to pay her. Yeah, but the offer is going to get you more money. I don't care. I don't want to, you know what I mean? I mean, that can happen. And occasionally does, actually. But you see what I'm really saying here? I mean, this whole focus on how much is the seller willing to credit the buyer for the cost, for the buyer's agent's compensation, is just how much is the seller willing to credit the buyer for anything? I mean, you're crediting the buyer for the escrow fee. You're crediting the buyer for the title fee. Maybe you're crediting the buyer for non-recurring closing costs or repair costs or interest rate buy-downs. All these things are, the bottom line is, seller agrees to pay all these things, but they're not really paying them. It's just built into the purchase price. So the buyer is basically, the buyer wants to put down as little as possible. So all these extra costs that are really buyer costs, they just build into the purchase price and they finance it. That's really what's going on. So if you look at it that way, nothing has changed. The only change is now buyer's agents can negotiate directly with buyers for your compensation. Your compensation is not determined by the other side. You decide how much you're going to get paid. Buyer agrees to it, then you figure out how that's going to work. How is the paperwork going to reflect that? But bottom line, that's the big difference. No longer is the buyer's agent compensation determined by the seller's side. That's why it's crazy for me when people still say, as a seller, can I advertise I'm willing to pay the buyer's agent X? I would say, why would you want to do that? Why would you want to commit yourself to a number? Isn't it really going to depend on the offer? That's the way I would think about it. Just like I, as a buyer's agent, what would be the point of ever calling the listing agent? How much is your seller willing to pay me? My response would always be, if you write a good offer, they'll pay you whatever you want. They'll buy you a Porsche. If you write a good offer, seller's not going to focus on how much they want you to credit their agent. So last thing on this is, let's say you do get an offer, and the seller for some reason credits counting, oh, I only want to pay the agent, less than you want. If I were the buyer's agent, I would say to my client, what they're really saying is you're just not offering enough money. I'm sure if you increase your offer, the deal will work. It's not that they philosophically care about how much the agent is getting paid. Okay. So what if that actually happens though, and the buyer, buyer says, you have a buyer broker contract 3%, you write an offer asking the seller to credit 3%, seller counters for some reason, I only want to pay your agent 1.5% or something like that. So you go to your buyer, increase your offer by 1.5%. Buyer says, I can't do that, I have no more money, or I don't want to increase it. I just want you to take less money. And I think your response to that should be, no. I think your response should be, okay, so you're telling me you want to buy a house that's out of your price range at my expense. Because that's what's really happening. If a buyer, are they going to go to the title company and say, I want you to take less money, title company? Are they going to go to the NHD company and says, you need to take a price cut here for me to buy this house? It's the same thing. I mean, if they went to you and tried, you can negotiate whatever you want. But I think that's the approach to take. And I think people are starting to come around to this. So I think. One last thing. When we talk about, you've noticed this, right? That up until about a month ago, you asked the seller to pay by checking the box in 3G3 and then attaching a form called the SPDB, right? Have you noticed that form is gone? So now just write on the contract, 3G3 is where you write in how much you want the seller, how much of a credit you're asking for. So 3G is where you put all the credits. Credit for non-recurring closing costs, credit for interest rate buy down, any credit you're asking for, it's all in the same place. And it's broken down 3G1, non-recurring closing costs, 3G2, other costs, 3G3, specifically the buyer's agent compensation. All right, enough on this? We can come back. There's other stuff to go in.
Psychologically, the
Yeah.
seller doesn't want to pay an agent's commission.
Yeah.
Agent to it as non-recurring, his commission, equal to his commission as non-recurring.
Well, I mean, you could, buyers can make whatever arrangements they want. They can ask for other credits to make up for it, whatever.
Right, but it's like you were talking
Yeah.
about, something psychologically, I don't want to pay your
Right.
commission, but he's not thinking it.
Right.
That's what your money's going for.
Right.
And then the other question was on open house, if it's not my listing, the open house register covers, it's so I can talk to them.
No, it doesn't. Because remember, the open house form is basically saying that the buyer understands that this agent is the listing agent. But if you're not the listing agent, you can't show it at all unless they sign a buyer broker contract. Answering their questions at an open house is the same thing as showing it. So you cannot show unless, number one, the buyer signs some type of buyer broker contract, or number two, it's your listing. And then we recommend, though, even if it's your listing, that they sign something acknowledging that. It's not that that's required, but for your own safety.
Question to the non-exclusive and exclusive
Yeah.
agreement for buyers.
Yeah,
An example that you write an offer with a non-exclusive, or you show a property to a non-exclusive buyer.
Right.
And they have the option to cancel right away. Does the continuation protection period
it still protects you if you showed it to them.
with the non-exclusive?
Yeah. In other words, whether you have a non-exclusive or exclusive buyer broker contract, if you actually show them the property and then they cancel it, then you're protected either way if they buy that property during the continuation period.
For the 90 days.
However long it is. Right. Okay. Let's talk about other stuff real quick. I mean, there are other laws to know about that I haven't mentioned yet. I think the most important one probably to think about is this whole balcony inspection thing. Every property in California now that has at least 3 units and has a deck or a balcony, you have to think about. That you didn't have to think about before. What do you have to think about? It says, was this balcony inspected? Now, we're talking about two different things. Number one, we're talking about apartment buildings, triplex, fourplex, anything with more than 2 units that has a deck or a balcony 6 feet off the ground, it has to be inspected. But it doesn't have to be inspected until the end of this year, 25. So you're put off of it. But every property owner in California, without exception, who owns a residential property that has at least 3 units and has a deck or balcony or outdoor staircase at least 6 feet off the ground, that's not decorative, people stand on it, and it's made or supported by wood or wood-based materials, that have to be inspected. Second category are condos. I own a condo in Culver City. It's part of a building with like 200 condos. A lot of the units in my condo complex have balconies or decks. Those have to be inspected too, but only if the CC&Rs say it's the HOA's responsibility, which mine does say that. If my CC&R said it is the unit owner's responsibility to inspect, nobody has to inspect it. So it's different than the apartment building. The reason I'm telling you this though is if you guys, any of you are working with buyers who are thinking about buying a condo, you have a new due diligence you gotta do. The first thing you gotta do is look at the building and see if there's any decks or balconies, not just on the unit they wanna buy, but on any units 6 feet off the ground made of wood. You gotta figure that out. Number two, then you have to ask the seller, do the CC&Rs say it's the HOA's responsibility to inspect, or is it the unit owner? Seller says, I don't know. Well, you gotta look at the CC&Rs to see what it says. What if the CC&Rs say it's the HOA's responsibility to inspect? The next question you have for the seller is, have they inspected yet? And by the way, the deadline for condos was end of December, last December. And the seller says, I don't know. You have to figure it out. You gotta somehow contact the HOA and say, did you do your required balcony inspections? And the HOA may say, no, we never did it. Or they might say, like mine is, oh yeah, we did it, we just don't have the results yet. Because you're gonna ask for the results. So what if you're representing a buyer buying a condo that has balconies, and the building has at least 3 attached, and the HOA either hasn't done the inspection yet, or they've done it but they don't have the results yet? I mean, the buyer can still buy it, but you have to disclose to the buyer the situation, so the buyer's aware that what could happen is the HOA finally gets around to inspecting, finds that all the balconies are defective, which means they have to be fixed within 4 months, which results in a special assessment of $50,000. When the buyer gets this special assessment a month after they bought it, they're gonna come blaming you. Unless you've protected yourself by educating them and saying, remember, this one hasn't been inspected yet, so this could happen. That's what I mean by protecting yourself. If they're willing to run that risk or factor that into the price, it's okay. But make sure you do your due diligence. See if there are balconies. Are they made of wood? Have they been inspected yet? If they've been inspected, what was the results? And if they're supposed to be repaired, have they been repaired yet? The good thing is, you only gotta do this once every 9 years. So if for some reason the balcony was inspected a year ago, you're good for 8 more years. But this is information you have to try to find out. Yeah.
When you say, you mentioned made of wood twice,
When I say what, I'm sorry?
you mentioned made of wood.
Yes.
Twice. Let's say it's wood subframe, but it's stucco covered, it's got a patio cover, deck cover over top of it.
In other words, what's the nature of the material that's supporting it as opposed to decorating or covering? It says supported by wood or wood-based materials.
What if the condo association that you're a part of has, hundreds or thousands of units? Do they have to inspect every single?
In other words, the building we're talking about, can they get away with just inspecting 3 of them and say, well, these are good, I'm sure the rest are good too. Believe it or not, that is a gray area. Some are trying to say that, but we don't see a loophole where they can actually do that. So right now our advice is that they gotta inspect every single one.
So you mentioned that if it's an HOA and CCR say it's a homeowner responsibility.
Yeah.
Multi-unit.
Right.
Does the homeowner then need to comply at the end of the year like other multi-unit homeowners?
At this point, no. So the law is kind of weird. You would think, just like if it was not a condo, all owners had to comply. Doesn't that mean that if it's a condo, and the CCNR says it's an owner responsibility, they need to comply? And actually, it doesn't say that. Probably because those are single-family units, and they didn't want to put this burden for some reason on single-family units. Yeah.
I assume CAR is gonna come out with a form that we're gonna attach as a disclosure.
Perhaps. We already got enough forms, but you're right. We probably need. I mean, bigger picture. Bigger picture. I bought a lot of. I've purchased condos in the past. I'm sure you have, your clients have. It's always possible when you buy a condo or anything part of an HOA that soon after you buy it, there's a new assessment, special assessment. This happens all the time. And that's not the realtor's fault. I mean, that's why the purchase contract says the seller has to provide you 12 months of minutes. Because theoretically, usually special assessments are discussed in the monthly, minutes of meetings of the board of an HOA, so you're not blindsided by it. And it's not the realtor's fault. It's not your job normally to keep up with what's going on in the HOA. Are there any pending things they're talking about? It is not your job. I'm just saying in this specific one, we're very concerned that this is a very specific one, and it's a mandatory thing, and it's gonna result in special assessments. I mean, I could be wrong, hopefully, but we think it's probably almost definitely gonna be the realtor's fiduciary duty to a buyer to do some investigating. And you're right, we may come up with a form, yeah.
Oh, no, I
Yeah.
think what you said,
Yeah.
would be just maybe, if
Yeah.
That's your buyers, just like, hey, look without me.
Yeah.
inspections, you have without me inspections.
Yeah.
Whatever.
Yes. All right. Let me talk fast now and tell you some other stuff that's going on. Thankfully, there's not a lot of other crazy new laws out there like there are some years. Buyer broker, we dealt with that. I told you the good news about the robocalls, the good news about reporting to the federal government about your information, not to do that. Contractors now, you can pay handyman, not $500, you can pay handyman $1,000 now without a contractor's license. That's gone up. Little random things. How long, when you're in the foreclosure process, what's the length of time between a notice of default and a foreclosure sale? Minimum of 110 days. New law says if someone's being foreclosed on and they list the property with a realtor, that adds 45 days. And if they put it in escrow, that adds another 45 days. So, whatever, no big deal. Probate. Property goes through probate. In other words, you have a property, it's not held in trust, someone passes away, the estate has to go through probate. You know, there's always been an exception that says if the estate includes real property, that real property doesn't have to go through probate if the real property is worth less than $184,000. Is there anything in California worth less than $184,000? Probably not. Now it's gone up to $750,000. So someone passes away, part of the estate is a $600,000 house. The will says the house goes to Judy. Judy can go to the court right at the beginning of the process and say, since the house is worth less than $600,000, just give it to me. I don't want to have to wait for the end of probate. The question the law doesn't address is who determines if it's worth more or less than $750,000. Probate courts are going to have to set up some process. I'm sure they have an appraiser or something. But there is a process. But this only works, by the way, if this real estate was the decedent's primary residence. Not necessarily right up until the day they died, but it was not an income property. Okay. Other things. New disclosure laws. Have you noticed, by the way, I don't know if you ever noticed this or care, that when laws, when there are new disclosure laws, now there are no new forms. I mean, I started before any of you probably, when there were no disclosure forms at all. You know what, 40 years ago, you know what the rule was? Let the buyer beware. That was the motto. Buyer beware, you're on your own. Then the year I started, we had the transfer disclosure statement. The next year we had the agency disclosure statement. The year after that, we had the lead paint disclosure. And there have been a few random forms like the defensible space form, that's a form. But there are also a lot of new laws that are new disclosure laws that don't have a form. They say you got to do this, but we don't have a form to do it. You know how we solve that problem? We have a form called the Seller Property Questionnaire. So when there's a new mandatory disclosure law, we just add it to that form. Well, guess what? We've added 4 things to that form in the last 6 months. It's not your responsibility. Sellers should read the stupid form and do what it says. But just for your information, what's been added to the SPQ in the last 6 months. Number one, there's one that says, seller, you have to disclose to the buyer if you've ever rented out this property. If you rented out this property 10 years ago, you have to disclose that you previously rented it out, and you have to disclose how the tenancy ended. Was it an eviction or was it a voluntary end? Second thing you have to disclose, I mentioned this last year, is you have to disclose if you've owned the property for less than 18 months, you must disclose to the buyer any repairs you did over $500 and who did them, the name of the contractor or the handyman. And you have to provide permits. Third one you have to do is, there's a new one that says, and unfortunately it's relevant in the world of fires that we have, it says, seller, if you have a well on your property, you got your drinking water from a well, but the well went dry or was destroyed in a disaster, and you had to replace it with some other source of water, you have to disclose that. And the last one, which is completely not relevant to Orange County, is if you're listing a house, if you're selling a house in a city where the city has an ordinance that says, if you have a gas-powered appliance and you want to replace it, you can only replace it with electric. You have to disclose that. trust me, there are no cities in Orange County or LA County or San Diego County that have such an ordinance. And the cities that have such ordinances are being challenged, and they're probably not gonna hold up anyway. All right, enough on disclosure. Any other new laws you should know about? Before I do the last laws, form changes you should know. The only, I think, worth mentioning is, you know how sometimes someone writes an offer, and the offer, offers are good for 3 days, right? But the seller then counters an offer after 3 days. So buyer writes the offer on Monday. Seller counters it the following Saturday. Hey, the offer died on Thursday. You're now countering a dead offer. Can you counter a dead offer? And our answer has always been, theoretically, the buyer and seller should do an addendum where they both agree that we have extended the time of the effectiveness of the offer. I don't know if any of you actually did this before, but the point is you don't have to anymore. Because the counteroffer form now says, this counter is, if accepted, this counter is effective even if the day of the counteroffer was beyond the day of the effective day of the offer. So the counteroffer, basically, if you sign the counter and the buyer accepts it, the buyer and seller are agreeing, yeah, I extended my offer long enough for you to counter it. And then what about the next step? What if the seller counters the offer on time? So the offer, within 3 days, the seller counters it, but then the buyer accepts the counter more than 3 days later. There's also a place in the counter, it says if that happens, the seller has to re-sign it at the bottom. So there are two different scenarios. One is you counter late. The second scenario is the buyer accepts your counter late. The first one is just taken care of. The form just simply says the counter offer is effective anyway. But in the situation where the seller counters and the buyer does accept the counter, but they accept it after 3 days, there's a new blank line at the bottom of the counter where the seller has to re-sign saying, I'm ratifying your late acceptance. Okay? All right. That's about it. Yeah.
And a broker can't sign it on behalf of the seller.
Right. Definitely. Correct. Absolutely correct. Okay. Yes.
Gov, could we revert to 3G3 in the RPA and spend a few minutes on what you could call protocol or policing?
Yeah.
In this respect, an offer comes in with a request for compensation.
Right.
No BRBC is attached to it.
Right.
The obligation of the listing agent to verify that the request is consistent with the BRBC. Some people are policing it, others aren't, because the BRBC can always be brought in later and filled in later. And so what's our position?
Yeah, a couple of very good, several questions there. First of all, let me point out the form change if you didn't notice. Up until a month ago, paragraph 3G3, the buyer would say, okay, I want you to credit me the amount of money I owe my agent, and then you would attach the SPVB to say how much you're asking. I already mentioned the SPVB is gone, so now you simply write on 3G3, seller, this is how much I want. But the next question is, what about, I mean, as you all know, I think, you can't ask the seller to credit more than you've agreed to pay your buyer. So if you've agreed to pay your buyer agent, pay agent 2.5%, you can't ask the seller for a 3% credit. Well, how does the seller know that what your BRBC says? I mean, how did they know that? Well, up until a month ago, it said right there in the purchase contract, upon request, buyer will provide a copy of the BRBC. It no longer says that. It now says buyer attests that they are not asking for more than they've agreed to pay their agent. So the seller can no longer just say, well, I want to see your copy of the BRBC, but actually the seller can say that. The seller can do a counteroffer and say, you want me to accept your offer? I need you to provide me the BRBC. And the buyer says, well, it doesn't say anymore in this contract that I have to do it. And the seller says, do you want me to accept your offer or not? you'll do exactly what I say if you want me to accept your offer. So that's one way to think about it. What if, by the way, the buyer does what I just said, and for some reason they ask the seller for a higher credit than they agree to pay their agent, and the buyer swear to God, I attest that this is true, and you find out at closing that the buyer actually did ask for a higher credit than they were offering. They were paying their own agent. The result of that is the buyer's agent gets paid zero. So obviously, as a buyer's agent, you have incentive to make sure your buyer doesn't do what I just said. They don't ask for, and you see what your buyer is asking for in the contract. So don't let your buyers ask for more as a seller credit in paragraph 3G3 than they agreed to pay their agent, you, in the buyer broker. But the next question, I think you're asking a bigger question, is what if I suspect that there is no buyer broker contract? What if I'm the listing agent and I suspect that the buyer's agent doesn't even have a BRBC, much less how much they're paying? I mean, it's up to the list. I mean, it's not that you have a duty to police that, but it perhaps is in your client's interest to know. But you'll find out at closing anyway. I mean, it's not too late at that point to say, okay, the deal closes and buyer's agent, you get paid nothing. And if you find out later, by the way, obviously, if you don't have a buyer broker contract in place when you show the property or write the offer, you're in violation of the law. Not only can the DRE punish you and the MLS can punish you, but your client can just say they shouldn't get paid. And the escrow can close without them getting paid. So there are all sorts of reasons not to do this as a buyer's agent. But as far as your real question was, I don't think it's the listing agent's job to police this. Your seller may want to police it. Your seller may say, I don't trust that no good BDI buyer's agent. You know, I want some proof. But it's not your job to police it. I mean, you explain to your seller the rules, and they may say, whatever. I know that person, I've done with them, blah, 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 I trust them, whatever. But it's not you're the policing agent. It's going to come out anyway in the closing. So, and it's not too late at that time to cover this. Let me wrap this up with the worst news. I saved the worst for last always. Only that it's getting harder and harder to be a landlord or a property manager in California. So the other new laws that I haven't mentioned all relate to rentals. There's 4 of them, real quick. First one is, listen to this carefully. If you're renting out residential property in California and you're renting out more than 1 unit, as of April 15th, you have to offer your tenant an opportunity. You have to say to your tenant, if you want me to, I will report to TransUnion or Experian or whatever, I will report to them that you pay your rent on time. Because some tenants, they have bad credit or no credit. They want to try to build up some credit. So it helps them if you, the landlord, report to the credit reporting agency that they pay their rent on time. And you have to do this if they ask for it, and you have to offer that, you have to make them aware that they have the right to ask you for this. How do you tell them that? Well, we have a new form. It's called the TRPR, Tenant Request for Positive Reporting. All of you that already have tenants, you have to give them this form by April 1st to tell them, would you like me to start doing this? April 1st, not April 1st, unfortunately. So, in other words, and if they say, yes, good idea, you are allowed to say, okay, I'm going to charge you $10 a month. Then they may say, well, hold on, not such a great idea anymore. But the point is, you have to make the offer. Now, we have already incorporated this into our lease form. So if you sign a new lease, ever since the form changed end of December, if any of you if you're doing a new lease and you use the CRR form, it's already in there. But I'm saying for those of you that have existing tenants, it's retroactive. It applies to them too, which is why we had to create a new form that you have to give them by April 1st to tell them about the rights that they now have. And if they want you to do it, then you have to do it.
Who's you, the landlord or us?
Both. Both. It's not I mean, the property manager, you're gonna get in trouble if the landlord doesn't do it. I mean, you know the landlord's gonna say, this is why I hired a property manager to take care of this. So yes, it is I mean, if you're just the leasing agent, you just brought the deal together, you don't have ongoing responsibilities. Unless you're getting paid to manage after the deal closes, this is not your job. But if you're getting paid as a property manager, it is definitely part of your responsibility to comply with laws like this. So yeah. Remember what I first said though. If we're talking about a landlord who only owns one rental, they don't have to do this unless the rental property has more than 15 units. Or unless it's owned as a corporation or LLC. But let's say I'm just renting out my house. I have one rental property, my house. Or I have a duplex or a fourplex or a sixplex. I own it in my own name. It's my one rental property. This does not apply to me. It applies if you have a rental property with more than 15 units or owned as a corporation or LLC, or it applies if you have more than one rental property. You've got 2 single-family homes, it applies to you, even if you own them in your own name. Who doesn't have to do anything? When I say you, I'm saying you, the landlord, have to do this if the tenant wants you to. You have to offer them the right to do it, and then if they want to do it, you have to do it. You have to report. You can charge them $10 a month. And you only have to report to one of the 3 credit reporting agencies, whichever one they pick. But you have to offer it and you have to do it. Yes. $10 a month, yes. I don't even know. We'll figure it out. I mean, I'm sure there's a way. I mean, well, you're right. We've got to put something out. And maybe even on that form. I haven't looked closely at the form. I'm sure TransUnion has a process where you can do it. Yeah.
You said held in corporate LLC, held in trust. Is that
trust? It's okay. It's held in, if the property's held in trust, and then you only have one rental property, you don't have to do this. It's only if it's owned as a corporation or LLC. Actually, an LLC that has at least one corporate member.
So if you have a client that owns through their trust, a single family, a duplex.
Yep, now you're into 2. They own more than, your scenario, they own more than one, they're renting out more than one property.
In the same county?
Doesn't matter, anywhere. If their other property is in Romania, they're covered by this. Actually, no one's going to know it.
But isn't it true that the tenant can opt out of?
The tenant doesn't have to ask for it in the first place, and of course, once they are doing it, all of a sudden they're not paying their rent on time. They can opt out. Yes, they can say, "I changed my mind. No longer report. No longer report my rent. My rental payment information." But you can even if they don't want you to. But that's always been true. You always have the right to do that today. You always have. Yeah.
So if the trust
Yes.
has 2 single family.
You're not exempt.
You still have to report.
Yeah.
Will they be signing something in writing that's saying that they're opting out of it?
And they don't even have to opt out of it. They have to opt into it. So, I mean, it makes you feel safer to get them to officially opt out of it. You don't have them to come back later and say, "You told me you were going to do this and you weren't doing it." I mean, they'd have to produce some paper trail where they did ask you or something. And it might be a good risk management practice if they don't want to do it. Like you said, get them to sign something acknowledging, I specifically don't want you to. That's a good. It's good. Yeah, you guys probably, anyone who's looked at the form knows more than me because I haven't had time to really look at the form. I should have looked at it before I came here.
I guess, how would you memorialize that you sent them the rights to opt in? Is there a form that says?
No, but how do you memorialize anything? You know what? I've said for years and years and years, and it's a pain and nobody does it, and I don't blame you, but the way to avoid problems is to memorialize every conversation you ever have with a client. At the end of every day, say, "Okay, did I talk to client number 1 today? Oh yeah, we talked. And we agreed that they were going to order a home inspection. We agreed that they wanted to see this product, didn't want to see this product. We agreed on this and this." Any conversation you ever have with a client where they agree, you and the client agree to something, it's always a good idea to put it in writing, send them an email, just want to confirm that you and I talked and this is what we did. So, I mean, there's no forms for that, yeah. 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 The whole thing is, I know what you're saying. Okay, so what if I own one home in my name, and then I own an LLC, another one in the name of my LLC? So is that two different owners? So I'm exempt because it's really two different owners, it's not the same owner. The law doesn't really address that. So once again, conservative advice. I think a judge would say, well, you still own both of them. Whether you own one, the point is you own more than one. So you better comply. Or I could be wrong. Be the test case, tell us what happens. We always want you guys to test out these laws and tell us the results. It's always good. All right, 3 more laws. All for rentals, property management fees. You have security deposit. You know, you can only collect 1 month now. If you own more than 4 units, you go to 4 units, you can collect 2 months security. But the point is, you can use this security for back rent. You can also use this security to do repairs or cleaning. New law, also April 1st, also not April Fool's, is starting April 1st, if you want to deduct from a tenant security deposit more than $125, in order to deduct for cleaning and repair, if you want to deduct it for back rent, I'm not talking about this, but if you want to deduct more than $125 from a tenant security deposit from residential property after they move out for cleaning or repairs, you have to provide the tenant with photographs before and after. So in other words, the day they move out, you take pictures, then you do their cleaning and their repair work, and then you take the pictures then, and then when you send them the notice that says, I'm deducting $1,200 from your security deposit for cleaning and repairs, you also got to send them the before and after pictures. It could be a thumb drive, could be a link, could be actual photographs in the snail mail. Somehow you got to give them the before and after photos. If you don't do this, you can't deduct. Starting July 1st, this even applies to new tenants. So you get a brand new tenant in August. I got to take pictures of the property before they move in. When they move out, I got to take them again. And when I do the cleaning, I got to take a third set. So I'm going to have to send them 3 sets of pictures if I want to deduct from anything more than $125 from their security deposit for cleaning or repairs. New tenants you have between now and July 1st, you don't have to take the pictures before they move in. You might want to, but you don't have to. Okay. Now, this same law says something else. The same law says, speaking of cleaning fees, no longer can landlords do the following. I have seen many leases where the tenant agrees in the lease, I agree that when I move out, I will pay the landlord for a professional cleaning or professional carpet cleaning. If you have that provision in your lease, it's not enforceable anymore. I mean, if they destroy the property, you can definitely take out of the security deposit the cost of a professional cleaner or a professional carpet cleaner. But if they give it back to you, just as clean as it was when they got it, minus ordinary wear and tear, you can't deduct anything, even if they pre-agreed in the lease that they would pay for something. You see what I'm saying? I mean, if they give it back to you in good condition, you can't make them agree, oh yeah, I promise I'll pay for a carpet cleaner or something like that. In fact, even if they don't give it back to you in good condition, so this new law says you still can't, seller, owner, you still can't charge them a fee for a professional cleaner unless it's reasonably necessary. What the heck does that mean? Who's going to decide that it's reasonably necessary that you hire a professional rather than clean it yourself? The pro-tenant judge you get is going to decide that, yes. The cleaning part, that's a good question. You see, even I can't keep this stuff straight in my head. Call the hotline on that one. email me. Email govh@car.org. I think it does apply. But you're right, because Airbnbs do this all the time, where they have a mandatory cleaning fee. I'm not so sure they can do that, but I apologize. I am not 100% sure. Sorry about that. What I just said, that's in effect. For April 1st, July 1st for new tenants. So we got two April 1st things. We got the reporting positive rental payment information, and they have to take pictures. And also what I just said about the not being able, if you had a tenant move out before April 1st, and your lease said they will pay for the cleaning, you can still collect that until April 1st. Okay? All right. Two more. I know this one the property managers hate the most. When you have a vacancy, it is probably standard practice to say to the applicant, okay, you need to provide me with a non-refundable screening fee. And you can charge up to $62, because I'm going to run a background check on you and all this stuff, and it costs money, and you got to pay me, and it's non-refundable. As of January 1st, they're no longer non-refundable. So if someone applies and they don't get it, you got to give them back the $62. So what's the point of collecting it in the first place, right? Because you can't keep it. Unless you do the following. Unless your practice is, every applicant I get, I'm going to send them, as soon as they say they're interested, I'm going to send them a document that says, for this unit, we're looking for a credit score of this, income of this, assets of this, no evictions, you've been on your job for at least 5 years, whatever you want to, however strict you want to be. You have to put that in writing, give it to the applicant, and also commit that, and I'm going to look at every applicant in order, and the first one who meets those criteria is going to get the unit. And if I find someone before I even get to your application, I'm going to give you back the money. So you have to commit to telling the tenant what you're looking for and commit to taking the first person who meets it. So you have no discretion. You can't interview people, you just have to take the first one. If you're willing to do that, you can still keep the screening fee you charge them. If you're not willing to do that, you have to refund the screening fee to every unsuccessful applicant, which means why collect it in the first place if I just got to give it back. So property managers hate this one, but that's the way it goes.
Does that include when they go on Zillow and just?
Good question. Or like rent spree or something like that. Let's say the tenant, who's pretty smart, says, I'm going to be looking at a lot of properties here. Rather than paying this fee to all these landlords, I'm just going to go to rent spree, pay them one fee, they'll give me a background check, and I'll give that to each landlord I'm applying for. If that's what they do, okay, fine. But what if the landlord says, if you want me to review your application, you have to go to rent spree and get a background check. So in other words, it's a requirement of the landlord. If that tenant doesn't get it, you got to refund the rent spree fee. Or at least the portion of it. So if they used it for 5 places, you got to refund 1/5 of their rent spree fee. How are you even going to know this? No one's going to know. This is a nightmare for property managers. But what can I tell you? I told you I was giving you bad news, and that's the bad news. So you got to deal with that. And the last one is interesting. Changing locks. Okay. And then I'll be done. Thanks for hanging out. Tenant comes to you and says, you know, my partner, my boyfriend, my girlfriend, whatever, they have a key to this place. And all of a sudden that's a big problem because this partner of mine is now a threat to me. Their physical violence is happening, violent threats are happening. So for my protection, landlord, you need to change the locks immediately so my bad partner or bad whatever doesn't have access. It's always been, it's been the law for quite a while that when this happens, landlord, you do have to change the locks within 24 hours. But the old law never addressed a couple of issues. Number one is who has to pay for that lock change? New law says the landlord. Second question, what if landlord doesn't do it in 24 hours? Tenant can do it themselves. Bill the landlord must reimburse in 7 days. And the third thing that this law clarified is, does the tenant have to provide any type of proof that this is actually true, what they're saying? Like a police report or something? And the answer is no. You have to take the tenant's word for it. Now what if every 3 months the tenant keeps calling you 10 o'clock? They're running into bad boyfriend after another. It doesn't matter how many times they ask for it. Well, can I evict them for asking me to change the locks too often? No. Keep in mind, though, that if you have a tenant who's month to month who's been there less than 12 months, you don't need a reason to evict. I always tell people this. Once you have a tenant 12 months, they are your tenant for life. Unless, I'm assuming the property is 2 or more units 15 years old or older. I mean, if it's a newer property, that's not true. Single-family homes, that's obviously not true. But if you have a rental, 2 or more units, and the property is more than 15 years old, once the tenant's there for 12 months, as long as they pay the rent, and you can increase it by, 8 or 9% a year, and they don't violate the lease, you can't just kick them out for no reason. The only way you can kick them out is owner move-in and substantial remodel. Whereas a tenant who's been there less than 12 months, or the building is newer than 15 years, or it's a single-family property, you don't need a reason. That's the beauty of renting out single-family. You don't need any reason at all to evict them. That's why we fought so hard to fight Prop 33, which would have changed that.
One person read, I had a rental property that I rented to a couple, they got divorced.
Yeah.
And the guy, I don't know who requested it this woman in his house.
Yeah.
She was calling me, telling me how to do the kickers and
Yeah, I mean, obviously the scenario I'm talking about is the tenant lives there and the bad person lives somewhere else. I mean, if the people both live there, you can't change the locks for one of them and not the other one, unless there's a court order, a TRO or something that this person can't come. You can't, I mean, unfortunately, you're caught in the middle of it. The guy I'm living with is the problem. You gotta get him out. It's this court order, otherwise I don't have to do anything. I can't do anything. So what I was talking about changing the locks because an outside person. Yes. Any more questions?
Regard to TRPR.
Yeah.
If that's coming into effect April 1st.
Right.
So if someone has a month-to-month tenant or a tenant that is coming due, but they want to renew their 1-year lease even before their 1 year has been
Yeah.
ended, the landlord doesn't have to give the TRPR.
Well, I mean, if you're renewing a lease and they're signing a brand new lease and you're using the CAR lease form, no, the extension form doesn't incorporate that language. So if you're doing an extension form, you'd have to provide them this form too on April 1st.
But before April 1st, if you're just using the lease extension form.
You don't have to do anything. But then on April 1st, you got to give them the form.
Oh, wait, then after April 1st, all tenants have to.
This is for everybody.
So every tenant that you have.
Yes. Everyone. Unless you only have one rental property owned in your own name or a trust that has less than 15 units.
What was the question?
You don't even need to know. I think we clarified. I was just wondering if you extend it before then, you have to still give them this form. I mean, they can say they don't want to do it. They never have to opt in the first place, and once they opt in, they can opt out later. Right.
But the landlord could say, by the way, required I give you this, but there's a little area on.
Yeah, point out to them they don't have to do it to opt. If you feel like it, yeah, if they don't read it, as they probably won't, you can point out to them, I have to give you this, but you don't have to do this. But as someone asked me before, if they don't pay their rent on time, you can report them anyway, whether they opt in or opt out.
Thinking about the private homeowners, their income property owners.
Yeah.
They're not accessing our forms or classes like
Right.
this. So how is that, how is that regulated? And what's the downside if they don't know about it,
Yeah.
they don't do it?
Yeah.
Who's monitoring it?
I mean, that's a good question.
Because they're trying to contracts, I think, you know.
I mean, my point is no one should ever rent property without hiring a realtor as the property manager, correct? Because that's the only way you can be sure that you're complying with the law, which is true. But what if they don't? I mean, I can't imagine this. Once again, there's not like serious penalties. I mean, the tenant's gonna come back and say, you violated the law, you never gave me the right for this. You're right, I didn't. And they could sue and say this, the fact that I couldn't maintain my credit is lower, my credit score is lower than it should be because you didn't tell me about my right to have positive rental information reported. Your actions have caused my credit report to be lower than it is. Therefore, I couldn't qualify for this house I wanted to buy, which cost $500,000. You owe me $500,000. They're not going to get that. But I mean, it's a private thing. There's no like criminal penalty or anything like that.
It's almost like ignorance is bliss. If we're handling it, then we are helping the standards you're describing, whether we thought.
In other words, that's an argument for not hiring a property manager.
That's exactly
Yeah.
right.
Good point. Good point. Yes, sir. Yeah. You guys can leave, by the way, so you have appointments, I'm sure. Go for it. That's a great question. I think that was his question. I probably didn't answer it properly. So the scenario is, even though the contract doesn't say, the purchase contract no longer says the buyer has to provide a copy of the BRBC. The seller can always require that. The seller can say, I don't care what the contract says. If you want me to accept your offer, I want to see your BRBC. So the buyer then provides it, and it's dated after they wrote the contract, much less showed it, it's dated after the contract. So obviously, in other words, the buyer's agent was in violation of the law because they clearly showed and probably wrote an offer even though they didn't have a BRBC. And I mentioned before, clearly that buyer's agent is running the risk of getting fined by the MLS because you could report them to the MLS. They're running the risk of disciplinary action from the DRE. But your question is, does that affect the validity of the purchase contract? In other words, even though the buyer agent broke the law, broke the settlement and the law by writing an offer or at least showing the property without a buyer-broker contract, nevertheless, they did it eventually, and the seller agreed that they would credit the buyer that amount. Can the seller make the argument, well, since you're in violation of this statute, that invalidates my contractual agreement to give you this credit? Have I go all that trouble saying the answer is, I don't know. I mean, the law doesn't address that. I guess we're talking about a big expensive property, like, multi-million-dollar property where it's a big number. I'm sure a seller's gonna basically say, I'm not paying it. And I don't have to, and you still got to buy it, blah, blah, blah. And it'll go to court, and a court will, it's not just because people that enter into contracts are in violation of certain laws doesn't necessarily invalidate what they've agreed to contractually. It's not necessarily the case. So that, I would say, at this point I can't say that that's the case, but who knows? Someone's going to test that. That's it. Yeah. Oh, really? Oh, really? Are you sure? If you can send it to me, I'd be very, very interested. govh@car.org. I'm surprised by that because this law is so new though. Usually cases don't happen that quickly.
That happened.
She's pretty sure, she sounds sure.
So same situation, do you have any idea of escrow's duty or what they should do? They get the BRBC from the buyer, instructions to pay, and that is less than what.
Yeah.
Because escrow could then say, we have a problem, they'll have a problem, so we can't help.
Yeah, right. And that's another great question that there's no great answer for. In other words, what is the escrow company's liability to police this? Do they have any responsibility to police this? And that's even, I mean, the escrow companies have been talking about this at their meetings. And at this point, there is definitely no, I mean, they might change their rules, which I don't think they've done it yet, to say, because escrows can police themselves, just like realtors police, you guys police yourselves, and they could pass saying if you're a member of the escrow association, you agree to follow these guidelines, and one of the guidelines is it's your responsibility to verify and compare. I mean, they're not necessarily going to see the buyer broker contract anyway. So does the escrow company have an obligation to reach out and insist on seeing the buyer broker contract? At this point, I would say no, they don't. Whether they're going to adopt some type of internal escrow industry policy, that's a different question. But the escrow company, they have no right to demand to see the buyer broker contract anyway, so they don't necessarily know what's going on.
Gov, the part that I think changes a little bit is the attestation that's put in there. Is that, and that, I mean, there might even be fraud there, really, in the scenario.
Yeah.
Was that a CAR thing, or was that a?
That was a CAR thing, yeah.
Okay, so that's in all the CAR contracts, the attestation.
Yeah.
And that plus the law,
I mean, that's a good point. In other words, even if that attestation wasn't in there, if a buyer is asking the seller to credit them more than they agree to pay their agent, they're violating the rules, with the consequence being the agent doesn't have to get paid at all. But now it's even stronger than that because the buyer is making an attestation, which means if the buyer turns out is lying, they can get sued for fraud. That's the whole point of an attestation. So maybe that's one more reason for the buyer and the buyer's agent to make sure this isn't happening, that they're not violating the rules. I mean, the risk of the agent, by the way, if I haven't said this, I think I did say it before, the risk of an agent of not complying with this law is, in addition to the possible sanctions and the possible fines from the MLS and DRE, is that would invalidate the buyer broker contract as far as them getting paid at all. So, she's standing there, meaning we have to wrap this up. We're going to make the...
You can make me the bad guy.
She is the bad guy. Last question.
So, but the new California law on the BRBC, what happens if you receive, what happens if the buyer's agent dates the BRBC as the same date as the offer, or if the listing agent says, oh, your client came and saw the property with or without you, and this BRBC you gave me is dates after that.
That's what we just asked, we're talking about. And that may not be relevant. I mean, in other words, maybe the seller is concerned about this, and the listing is concerned about this, and you're going to say, we're not going to accept your offer, agreeing to pay you until we do have proof that you got a BRBC, and then if you find out they don't have one, you can just say as a matter of principle, we're not going to agree to the deal at all. But if they've agreed to pay the credit, and after that they find out that the buyer's agent violated the law, that was my point, we don't know if that necessarily means that means you don't have to, the seller no longer has to provide that credit. It's not clear. Okay, it's just not clear. You had a question real quick.
Yeah, the 18 months.
Yeah.
Parent died and trustee now inherits the house, and they made improvements. Is that the same thing in purchasing it?
Yes.
Okay, so they need to disclose why the mother still alive,
Yes.
made some improvements, and then they inherit and finish the.
Well, no, they have to only if this knows what happened since after they inherit. Yeah. All right. If there are more questions, I'll hang out. Otherwise, thank you very much.
Thank you guys for taking your time to address
greatly appreciate it. Thank you to all the sponsors that showed up this morning.